Then we will examine the case.
Yes, madam. Lord, this is an application under section 483, praying for bail. Lord, my client was apprehended on 1st of September 2024 on the basis of a credible information that was received by PS Rangat. A team was formulated and a raid was conducted. And during the raid, 10 grams of methamphetamine was recovered
Is
on
it
intermediate quantity. It is intermediate quantity. It is intermediate, admittedly. It is an intermediate quantity. Then thereafter, your Milord, a case under section 22B of NDPS Act was invoked and he was taken into PC. Then he was remanded back to the judicial custody. After
Now you are relying upon the order of the coordinate bench dated 11 November 2020.
yes, my lord. Yes, my lord.
Now there is a sharp distinction in between
My lord.
these two matters.
My lord.
These two issues.
My lord.
The order passed by the coordinate bench on 11 November 2024.
My lord.
There no recovery from that from the
Both of them were traveling in the same bus. Yes.
Implication was
Statement of the co-accused.
Statement.
Yes, my
now,
lord.
your case is there is a recovery from.
There's a recovery which is an intermediate quantity. Which is an intermediate. Yes.
Quantity.
So the bar under section charge sheet, there were 3 accused persons.
Yes.
Initially the FIR was chalked out under section 22B, but at the time of filing of the charge sheet against all the 3 accused persons, 22C, 29 of NDPS Act.
Charge sheet was filed.
My lord. The charge sheet herein, my lord, was filed. My lord, may kindly come to. It was filed on 14th December 2024.
14 December
2024.
Now, show us from the case diary about the recovery.
Lord, may kindly come to page number 25 of my application, my lord.
25.
25, my lord.
Page 25.
Page 25, my lord.
Which page?
Seizure list, it is there, my lord.
Commercial code, it's not a commercial code. And charge sheet has already been filed.
There is a bar under section 37 of the NDP.
Yes, has place before us section 37. It is silent about intermediate quantity.
But can you see conspiracy? This accused the possession from his pocket it was filed.
Yes.
10 grams. And what was the information?
You are absolutely correct. Petitioner in this case is not on the same footing as the accused in the previous matter.
Lordship.
As the accused in the previous matter, he is in what?
Lordship.
Now there was no recovery from that accused.
Lordship.
And not only this, implication so far that accused was concerned based on the statement of the co-accused. It has got no evidentiary value.
Lordship.
But so far present case is concerned, rigor of section 37 does not apply in this case. And your charge sheet has already been filed. So what is the necessity of keeping the accused or applicant incarcerated during this period?
3 grams have been purchased from that person who is in custody. That is more than 3 kg of methamphetamine. And it was
yes,
a racket.
Another person.
Yes, he's in custody.
From
against him,
person, from him, as we have found that this is apparent from the order passed by the Sessions Court.
3.090 grams.
0
kg.
So
he is in custody.
But so far the present petitioner is concerned only 10 grams.
10 grams. But he has purchased from there. You are selling in the market.
Charge sheet has been filed. An application for bail under section 483 of BNSS 2023 in connection with
Rangat,
Is the PS, Rangat PS number
in connection with Rangat Police Station,
70.
case number 78 of 2024, dated 1st September 2024, under
22B.
22.
under section 22B/22C/29 of the NDPS Act, 1985. Then cause title, দিয়ে দেবেন Sri Sanjeev Kumar Halda. This is an application under section 483. দরকার নেই এটা বলার, উপরে বলা আছে, please strike it off. Learned advocate representing the applicant submits that petitioner may be granted bail since the recovery which has been made from him,
Allegedly made.
recovery which is alleged to have been made from him is less than commercial quantity, and charge sheet has already been filed on
14th December
14th December.
2000.
14th.
14th December, কোথা থেকে বলছো?
আমি লিখে দিলাম বললো 14 December 2024.
On 14 December 2024. Stop. During course of hearing, reliance is also placed on behalf of the applicant on order dated 11th November 2024, passed by coordinate bench, whereby another bail application was allowed. Thereby, one co-accused, namely Ashok Kumar Maiti, was granted bail. Stop. It is contended on behalf of the petitioner that petitioner may be granted, petitioner may be treated equally. Next paragraph. Learned advocate representing state has opposed the bail application on the ground that a recovery has been made from the petitioner hearing, on the ground that recovery of psychotropic substance has been made from the petitioner, and the co-accused who was granted bail, video order dated 11 November 2024, is not standing on the same footing. Next paragraph. We have considered the respective submissions made on behalf of the parties and perused the case diary produced before us and examined other relevant materials. Stop. From the case diary,
Just
charge sheet.
from the-
From the case diary, we have found
এইটা সেই, এটাই সেই।
we have found that that the quantity of psychotropic substance which has been recovered from the petitioner is less than commercial quantity, and less than commercial quantity, and charge sheet has already been filed on 14 February 2024.
14 December.
14 December 2024. Stop. It needs to be recorded herein that it is rightly pointed out by the learned advocate representing the state that the petitioner or that the co-accused who obtained who was enlarged on bail video order dated 9 January 2025 is not standing on same footing, since from that co-accused no recovery was made and implication was based on statement of another co-accused. Stop. However, if the present case is considered independently, we find that the recovery made from the petitioner is less than commercial quantity. As a result whereof, rigor of section 37 of the NDPS Act is not attracted. Stop. In addition thereto, charge sheet has already been filed. Stop. Next paragraph. In view of aforesaid situation, we are inclined to grant bail in favor of the petitioner. Stop. Next, the petitioner shall be released on bail upon furnishing a bond of rupees 10,000 with two sureties of like amount each, one of whom must be local, to the satisfaction of
Special court. Tell special court.
CJM Mayabandar. The bond is to be accepted by the CJM Mayabandar.
CGM Maya.
just a minute. Additional sessions judge, Northern Middle Andaman was in previous matter, it was directed that additional sessions judge Northern Middle Andaman.
Yes, my lord. Subject to the satisfaction of learned additional.
Yes. So why in this case, Chief Judicial Magistrate Maya
Because the bond is to be accepted by the Chief Judicial Magistrate.
That is another aspect of the, because the register is maintained in the office of the Chief Judicial
My
Magistrate.
lord made that the
additional sessions judge.
Additional session
To the satisfaction of additional sessions judge, common North and Middle Andaman, Mahabandar. Stop. Petitioner shall regularly appear before the trial court. Now, petitioner shall appear before the trial court on each and every day of trial, and shall not intimidate the witnesses and tamper with the evidence. Stop. Petitioner shall appear before the trial court till conclusion of trial. Stop. In the event if any of the aforesaid conditions are infringed, is infringed, the bail shall be cancelled without reference to this court. Next paragraph, the application being CRM within bracket MBBS close bracket /2/2025 is allowed and disposed of. Grateful.
One shall not leave this side without permission.
Shall not leave the
This island, Andaman and Nicobar Island, without prior
Permission of the trial court.
add another condition that till conclusion of trial, petitioner shall not leave Andaman and Nicobar Islands without permission of the trial court.
I'm grateful.
Subject to the provision of this তাকে বলতে হয় 317 এখন কত
Turn to the learned advocate representing the state respondents or representing the state. That will be prior to disposal. This sentence.
Item number 2, 9 of 594.
Your Lordship, I am for the
last
petition.
one.
Your Lordship, may kindly see the last body.
Yes, yes, sir.
What is the position now?
Seek this communication from the registrar general.
Register General, High Court, our court. Yeah, yes. This one. General resolution. Seven positions. Solution. State condition. President of the solution. Yes, what is your stand with regard to section 32 application?
This interim thing, my lord, this I'll have to take instructions for. I can file a.
Because the formation of selection committee is under consideration by the Honorable Supreme Court. So therefore, any steps can be taken that may not be in terms of the decision which is to be taken by the Honorable Supreme Court.
Fine.
So therefore, that is not possible at this stage since the issue is pending before the Honorable Supreme Court. But come to this
Yes,
part of the
interim
resolution of the appointment committee.
This ad hoc
Yes,
arrangement.
ad hoc arrangement under section 32.
I-
The only ad hoc interim management contemplated in the correct concerned statute that is the Consumer Protection Act 19, section 32 thereof, which empowers the state government by notification to direct the other district commission specified in the notification to exercise jurisdiction in respect of that district. That is the Andaman and Nicobar. Now it depends upon the, as such, we are of the opinion that a matter regarding interim management can be referred to the Andaman and Nicobar administration, which comes within the purview of the expression state government. So what is your stand?
That will file an affidavit.
Why you can affidavit?
No, this is.
How many affidavits will you file? It's a 9 January 2025 communication,
I know.
Mr. Chakraborty.
My lord is received on 15 January. 15 January, my lord, then I've only received it just now, my lord. We'll take instructions and. Because my lord, we have to.
Very well, by filing a report, you express in the
Yes.
form of affidavit, you intimate the court with regard to your stand
Yes.
as decided by the administration of the High Court of
If
Calcutta.
I'm not mistaken, there is only one district. So I'll have to then.
There are
take the-
two districts, consumer forum is only one. So
Only one, so.
There are two districts, one is Andaman and
Three districts.
three districts.
what are these districts
South, North, Middle Andaman and Nicobar.
and Nicobar.
But we have only one
So-
consumer forum. So in from these districts, we cannot make a, the administration.
Yes,
cannot
so
make
therefore
any changes.
32 per se may not be applicable.
We can take assistance from the district of West Bengal. That can be done.
Which is why,
That the court.
Calcutta.
For last 2 years.
Calcutta, you are too big.
that is why, which is why I am saying that I will have to file a report.
Really, you need to respond
Yes,
on this proposal made by the committee
yes,
for appointment of president and female
Fine.
member in the, yes. Today, learned advocate representing the respondents, or you are representing the administration.
yes, ma'am.
Learned advocate representing all the respondents.
No, I.
Even of India. The learned advocate representing Andaman and Nicobar administration has placed before us one email communication dated 9 January 2025, enclosing a resolution adopted in the meeting of the selection committee for appointment of president and female member in the District Consumer Disputes Redressal Commission within bracket DRC close bracket. Where is Stephen? Oh, very well. Close bracket. Which was held on 8 January 2025. Stop. On perusal of the resolution, it appears that formation of the selection committee for appointment of president and members of the District Consumer Disputes Redressal Commission depends upon the decision to be taken by the Honorable Supreme Court. But as an interim measure, the committee has mooted a proposal in terms of Section 32 of the Consumer Protection Act 2019 in order to direct any other district commissions specified in the notification to exercise the jurisdiction in respect of Andaman and Nicobar Islands. Stop. Next paragraph. This court has posed query to the learned advocate representing the administration, or this court has posed query to Mr. Shatadru Chakraborty, learned senior advocate representing the administration, as to what steps or as to the decision taken by the administration on receipt of said resolution dated 8 January 2025. Next paragraph. The learned advocate representing the administration has prayed for accommodation to file a report in the form of affidavit disclosing their stand on the resolution and on the recommendation made by the committee of the High Court at Calcutta dated 8 January 2025. The committee should be stated as selection committee. Stop. Next paragraph. List the matter. Before the next available circuit on 24th on 24th February 2025, in order to enable the administration to file affidavit in the form of file report in the form of affidavit disclosing the stand. Stop. As an interim measure, this can be done. Any district consumer forum can be empowered to function as the forum of.
There will be a difficulty because my lord, the state commission here will not have jurisdiction over district commission in West Bengal, but we'll have to find some solution. No, it has to be state commission. No, but
State commission?
Okay, the state commission here, my lord, is the Andaman and Nicobar Islands. Now, this contemplates the subject to my lord. I'll look into what my learned senior friend is saying. But my lord, this contemplates a situation where the state commission transfers the matters of a particular district under its supervision to another district within its supervision. The difficulty here is that there is only one district, there was only one district commission.
Your contention is the state commission of the state of West Bengal.
No,
Andaman and Nicobar is not coming under the purview of the state commission of the government.
the state commission, Andaman Nicobar Island State Commission is there. But if there is, since there is not more than one district. So I am trying to understand that how will the work of the district commission, which was functioning here, be transferred to some other district, because there is no other district commission functioning in Andaman and Nicobar.
Andaman, but you can seek any officer or
Whether
having experience to handle
now
the
whether the question
Any district under the state can function as the commission. So far, Andaman and Nicobar.
the question is,
West Bengal.
so whether
District commission under West Bengal can.
no, whether the West Bengal, no, how will the question will, we'll have to work. Very understand.
The decision has to be taken in terms of section 32. We need to consider what is the purpose of section 32.
And whether, but whether the question, I'm not saying we'll have to try to find a solution. I'm not saying.
Yes.
Question.
Try to find out.
Maybe
Yes, next.
make to the West Bengal State Commission. I don't.
If the litigant,
How long they will suffer?
give the remedy, you have to, since you have, you introduced a legislation, you have to give a remedy.
The difficulty my lord will appreciate that state government, West Bengal, government of West Bengal and government of whatever the administration.
Understood,
Any district authority can function as a district authority now.
District under the state government. That is the difficulty. That is the difficulty.
Does not say.
Anyway, I'll look into it, man.
I'm not trying to distinguish it since it is union territory.
This is a different.
We will come back.
We'll have to look into it. We are not, it's not an adversarial thing, man. We'll try.
Yes. Because litigants are suffering.
Yes.
Up here, sir.
Yes.
Don't have consider.
Next.
Item number 3, WPAP 11 of 2024.
My lord, in this matter, I am for the NTPC Limited, my lord. My lord, I have been served copy of the, I am the added respondent, my lord. My lord, you have been rejected.
Outage.
Last occasion, also kind enough to add entity in the party, manner, they were added and served and is appearing.
Yes.
I am appearing on behalf of NTPC Limited.
Yes, I responded, yes.
Yes, my lord. My lord, in this matter, my lord, actually the policy has been decided by the Minister of Power, my lord. They have decided to set up a power generating station at Andaman, my lord. And my lord, the decision should not be taken by the NTPC, my lord.
They have set up a power distribution unit.
No, my lord, we are only the generate the power, my lord. We are generating unit. We are not distributing, my lord.
Energy?
My lord, actually, one subsidiary has been set up by NTPC Limited, my lord.
Solar, my lord. Follows may kindly come to.
No thermal, no hydro.
We are shifting over to LNG.
But my lord, one thing, my lord.
We cut short the matter.
What?
Report filed by the central government. But wait 10 minutes, then it will be easy to manage.
Just a minute.
Possibly the administration is.
Union of India Ministry of Power. Mr. Tulsi Lal has filed, yes, yes, page 10,
Page 10, my lord.
yes.
As the administration is concerned, my lord, and the central government is concerned, I think they have nothing more do, my lord. It's basically the NTPC now. If my lord would see at page 10, paragraph 1, my lord, establishment of 50 megawatt LNG.
Just a minute,
My
let
lord.
my brother. Another report, there is another report. Yes, yes. Have you got it? Yes, this one. Come to page 10. Just a minute.
My lord.
Yes, yes, this paragraph, yes.
My lord, the first issue, my lord, the crisis as to how it is to be sorted out is in these 3 paragraphs.
Yes, establishment of 50 megawatt.
Megawatt LNG power plant. Answering respondent has directly
LNG power plant means,
liquefied nitrogen
gas. Yes,
My lord, answering respondent has directed NTPC Limited to reinitiate the process of installation of 50 megawatt regasified liquefied natural gas based power plant in Sri Vijayapuram, Port Blair for enhancing the reliability of power supply in South Andaman Islands. And notice inviting tender has been published on 7/11/2024 after filing of the present appeal. My lord, let NTPC, my lord, file a status report as to what is being done as far as this is concerned, my lord.
yes.
There are other, my lord. Now, number 2, strengthening and distribution infrastructure under revamped distribution sector scheme, RDSS, an amount of 516 crore has been sanctioned for distribution infrastructure work, including we are not concerned. NTPC is not concerned with 2. NTPC is concerned now, my lord, with 3 on the next page, my lord.
Installation of 20 megawatt.
Yes, installation of 20 megawatt battery energy storage system by Solar Energy Corporation of India Limited is in the process of tendering. Now here, my lord, I've skipped the other day, my lord, they also be.
Let the first steps be taken.
My lord,
It is indicated in one.
my lord, let them file a status report as far as 1 is concerned, my lord.
Have you seen the affidavit filed on behalf of the Union of India?
My lord, no, not yet been received by me, my lord, but my officer also concerned may be received by, but yesterday evening, my lord, I have got the copy of the petition, my lord. I have not yet been.
My friend just now called me up saying my number on my service letterhead for the link. So
what you have served? Only
I have served the department with the entire thing, my lord. I have served the local.
One thing.
I'll
send a copy of the petition.
Copy has already been received, my lord. My petition has been received by me, my lord.
You received the counter affidavit filed on behalf of Union of India, respond number 1.
Well, till today, my lord, I have not yet received. I know maybe the concerned officer may be received or not. I don't know. Yesterday night, my lord, I have received a copy of the petition, my lord. My lord, actually, the NTPC had to set up a subsidiary.
That
My
was
lord,
28 January with the entire set.
maybe, my lord, maybe. I'm not denying. I'm not denying, my lord.
It's casually, my friend. सब दिया ना बोलता बेबी
The notice NIT was issued on 7 November 2024.
Yes, my lord.
Government has directed NTPC to reinitiate the process of installation of 50 megawatt regasified liquefied natural gas RLNG based power plant in Port Blair for enhancing the reliability of or for enhancing the power supply capacity. Now,
Yes,
what taken because already
my lord, on the
in November 2024.
my lord, in this regard, my lord, NTPC set up a subsidiary company, NTPC Vidyut Vihar Nigam Limited, my lord, to set up the generating project, my lord. My lord, we have not yet received full instruction, my lord. The copy of the return has received by me on yesterday night, my lord. Kindly give me directions. Kindly give me some more.
This court fact, you need to file a report in the form of affidavit with regard to the steps taken based on the statements as made in page 10, paragraph 1 of the affidavit used on behalf of the Union of India.
Yes, my lord. My lord, yes, my lord.
Press to supply a copy of this affidavit to you and a copy of the petition.
Once again.
Yes, but NTPC will not be my file, my lord. The subsidiary company.
No, he is saying it is in the department, so you obtain instruction and prepare the affidavit, a report in the form of affidavit, file it on the next date.
My lord, kindly give me 3-4 weeks, my lord. Without my more time, my lord, I have some difficulties, my lord. My lord, but NTPC will not a party, my lord. My lord, actually, it's a subsidiary of.
Otherwise, you have to direct the chairman of NTPC to remain present before. My lord, right
No,
now.
no, no, my lord. I'm within 2 weeks, my lord. I'm ready to file. My lord, my lord.
I have done that now.
My lord, I
Fortnight time, not more than that.
yes, my lord. I filed, my lord. My lord, kindly take in record, my lord. Actually, NTPC not a appropriate party, my lord. The NTPC subsidiary.
Enough is enough.
My lord, NTPC is a subsidiary setup, my lord. That they should be.
Don't disturb this court in this fashion. Please wait. Dictate order.
Yes, my lord. Yes.
The matter is heard in presence of the learned advocates representing the petitioner, Union of India, and additional respondent. NTPC. Is it NTPC limited or corporation?
My lord, may I submit one thing, my lord? Actually, one subsidiary has been set up.
It is NTPC limited or corporation?
NTPC Limited, my lord. NTPC Limited.
NTPC Limited. It's
Yes,
wrong carried. NTPC Corporation. National Thermal
Or corporation
Corporation is limited.
limited, the word limited is to be inserted.
I don't think any.
National Thermal Power Corporation is National Thermal Power Corporation Limited. National Thermal Power Corporation Corporation simply. You are not audible.
NTPC Limited.
Yes, rightly done. কি বলছিলাম? NTPC.
It's NTPC limited.
NTPC Limited.
Limited, it's showing limited.
NTPC Limited. NTPC Limited. Stop. Next paragraph. On perusal of the affidavit used on behalf of Union of India, it appears under paragraph 6.5 within bracket Roman capital 1 close brackets. It has been stated that the Union of India has directed NTPC Limited to reinitiate the process of installation of 50 megawatt MW regasified liquefied natural gas within bracket RLNG close bracket based power plant in Sri Vijayapuram within bracket Port Blair for enhancing the capacity to supply electricity to the inhabitants and establishments in the area or in the islands. Stop. It is also stated therein a notice inviting tender has been published on 7th November 2024. But after that, the steps taken by NTPC Limited is not apprised to this court. Learned advocate representing NTPC Limited has prayed for accommodation to file a report in the form of affidavit disclosing the measures taken by such authority for enhancing the capacity of supply of electricity in the islands. Stop. Next paragraph. Hearing of this matter stands adjourned till till 19th, today we are on 5th, till 19th February 2025, when it will appear before the coordinate bench subject to convenience in order to enable NTPC Limited to file a report disclosing the steps taken by them, disclosing the steps taken in the meantime.
My lord, kindly.
My lord.
Kindly. As far as the affidavit is concerned, report filed with central government, it also appears there are two issues. The upgradation of the solar power plant also.
So let this.
My lord, let them also be added, my lord.
Let this entire issue
It appears, my lord. Stage by stage, let upgradation be made. Otherwise, if the court is monitoring, my lord, the things would move fast, my lord. Because it appears on 27/10/20. Where the union has stated this. Paragraph 11, page 11, my lord. Page 11. Paragraph 3. Roman 3. Installation of 20 megawatt battery energy storage system by Solar Energy Corporation of India Limited is in the process of preparing a copy of so and so notice dated. But is it still, it comes under Solar Energy Corporation of India Limited is a separate entity. So kindly permit me to add them also a party, my lord, and let them, there be a direction that we should also file a report, my lord. Since it has already, it is also stated under paragraph 6.5 within bracket Roman capital 3 that steps are being taken for installation of 20 MWH megawatt small h, MW small h, MW capital. Process what I have stated. Installation of 20 megawatt battery energy storage system within bracket BESS close bracket by Solar Energy Corporation of India Limited within bracket SECI. We find it apt to grant leave to the learned advocate representing the petitioner to further amend the cost title of this writ petition and add Solar Energy Corporation of India Limited within bracket SECI close bracket as another additional respondent. In course of this day, stop. After such amendment, Solar Energy Corporation of India Limited shall be served with notice enclosing copy of the writ petition and affidavits, as well as the order passed by this court today by fortnight thereafter, and an affidavit of service be filed on the next day. Let fortnight directed to file a report. By 10 days. My lord, may I humbly submit, my lord? Let them, they have already initiated tender process. No, let Solar Energy Corporation be represented. Otherwise, how will it? Yes, they have issued a tender notice. Nothing is happening. Yes, next matter. My lord, may I submit one thing, my lord? No, please don't. I will report next date. Otherwise, we have no alternative to direct your chairman to remain present. No, my lord. I will be comply your orders, lordship's order, my lord.
Your lordship, I am for the respondent. Your lordship, documents, paper book is required to be filed by them because number of documents are not there.
Yes. What is the matter about?
Here, my lord, there was an earlier, my lord, round order passed by the division bench, my lord.
In this matter?
No, yet not in this matter, in earlier round, my lord. Earlier round matter had travelled up to this court, where, my lord, the reservation, my lord, so far as the number of seats, etc., that were reserved and what was in the unreserved category was changed after the issuance of the vacancy notification. So the court held this division bench after hearing both parties passed a detailed judgment saying that it was open to make the to vary the vacancies, however, giving them liberty to amend the original application to challenge the decision that was taken to vary the number of seats that were reserved. Because as a result,
for recruitment,
seats for by not reserved category, my lord. So what number of seats in unreserved and number of seats in reserved category. It is because of this change that according to the original applicant, she would have qualified, but she couldn't qualify because there was a change in this. Now, my lord, that after the
So
amendment.
what is the change took place after initiation of the selection
Yes,
process?
yes.
Yes.
It
So how the game can be changed? Rule of the game can be changed after
Court has
initiation.
held that the division bench has held that the advertisement that clearly stated that the number of seats was only tentative. So that issue has attained finality in the division bench earlier, but the division bench granted them liberty to amend the original application to challenge the decision in the sense that whether this change was in accordance with law or not. Because their contention is that as a result of this change, the reservation exceeds 50%. According to us, that is not so. So, my lord, this was heard before the CAT and the CAT has held in their favor. So, my lord, that order has now been challenged by way of this writ petition, my lord. This requires hearing, my lord. Anyway, my lord,
Paperwork, they have to file the paperwork
paperwork has to be filed.
because all papers.
No scope. Where is the order of the administrative tribunals, Central Administrative Tribunal, page 82, annexure P2.
And my lord, it is yes, my lord, page 80.
So you amended the original
Yes,
application
yes,
in terms of the leave granted by the honorable petition bench.
Yes,
After
In terms of the leave granted by the coordinate bench, you amended the writ petition, original application.
yes, after,
Then
yes,
this amended application, original application was heard and it was decided in your favor.
yes, yes,
So which prompted the
administration to file this
yes,
application.
administration to approach this court,
Yes,
challenging that decision.
decision, yes.
So it needs to be heard.
You know,
Have you filed your affidavit of service?
I am there. Only one respondent.
Service is complete. Service of notice is complete in connection with the writ petition in terms of the order dated 27th January 2025. Stop. Next paragraph. Today, writ petitioners and original applicant / respondent are represented by learned advocates who have jointly submitted that there is no scope to pass interim order.
Yeah.
Stop. It is contended on behalf of the parties that the issue involved in this writ petition needs to be heard finally. Next paragraph. Let paper before the court before the tribunal pleadings or exchange. Reply
Yes,
is under.
yes, you know.
Let paper book be filed by let informal paper book be filed by 4 weeks.
My lord.
By 4 weeks from date. Stop. Learned advocate for the writ petitioners is directed to serve copy of the paper book by 7 days thereafter.
You know,
Upon the learned advocate representing original applicant / respondent.
yeah.
Next paragraph. List the matter before the next available circuit after the time fixed herein above for filing paper book and serving copy of the same upon the respondent.
My lord. I think number 5, my lord, we were required to file the affidavit in reply, my lord. I am reading it in court.
It's a short matter, it can be taken.
Matter can be fixed, my lord. I'm just filing it today, my lord. Let it come not today, my lord, tomorrow.
Then it will be before the next available circuit. Affidavit in reply filed on behalf of the petitioner. Affidavit in reply filed on behalf of the petitioner is taken on record. Learned advocates representing the parties have prayed for accommodation. Next paragraph. List the matter before the next available circuit.
My
Next available circuit under the same heading. Why under the admission? It should be under the heading hearing.
No.
lord.
Section 5 is not
Section
allowed.
5, my lord.
Oh, affidavit in reply in respect of section 5.
Yes, yes, my lord.
Affidavit, oh,
In respect of condonation, act.
how many days delay?
200 and odd,
200.
274.
Government,
That's why it is not permissible. That's why I thought that it can be hard.
huh?
If
It
he
can be
says
hard.
it is not permissible,
And,
it will be argued in the next circuit, my lord. He is opposing.
Because the 90 plus 30 days as per the.
Will come back.
Item number 6. SHS 24.
Lordship, in this matter, I am for the appellant. After the liberty given by this honorable court, I have changed the limitation period. There is a delay of 33 days, Lordship, in this matter. All the respondents have been served, Lordship.
Delay of how many days?
33 days, Lordship.
দেখে নাও কি গ্রাউন্ড নিউজে লিখে একটু ডিসকাস করা See, it was not described correctly. The number of days,
Only the number of days.
delay of number of days.
Lordship. Earlier I wrote 30 days, Lordship. And there was a calculation mistake.
We amendment একটু বলে দিই in terms of the order passed by us.
আচ্ছা,
The application for section for
the application by can one, right, can 1 of 2024. Stop. বলবো এটা।
ওটা একটু কমপ্লাই হয়েছে বলে দিই।
According to the leave granted, as per the leave granted by us previously to amend the application for condonation of delay, the আচ্ছা ঠিক আছে, হ্যাঁ। The application has been amended, stopped, and the same is and stopped, and upon consent of the parties, the same is taken up for hearing. Stop. আচ্ছা। Further, advocate use the averments made in the application explaining the delay in preparing this appeal. Stop. As we are satisfied that the sufficient causes are available which prevented the petitioner in preparing the appeal within the prescribed period. Stop. Accordingly, the
Within the
application
statutory period of
within the statutory period of limitation, and accordingly the application is allowed, delay is condoned. Delay is condoned.
can
Disposed of. Well, now, yes, well, we shall admit it.
Lordship, it's accommodation, Lordship.
Under
I
which
would say it's fine.
question of law.
Yes, Lordship. There are 2 points are there, substantial points. Give me some time, Lordship. I would satisfy it.
let the why you have not taken out any application for admission of appeal under order 41 rule 11? Under the rules, it has to be admitted, Lordship. So why you have not taken out an application?
Lordship, generally we used to file the appeal, and after section 5, the appeal is automatically taken for admission hearing, Lordship. So
It has to be admitted formally under order 41 rule 11.
Lordship. But a separate
Then it
application,
needs to be heard by the land sale judge. That is the procedure. So why you have not taken out an application?
generally, Lordship, here we are not filing a separate application. Here, Lordship, in practice, we have
Let the appeal be placed. Let the appeal be placed on board before the next available circuit under the heading admission here. Under the heading.
Oh, sorry.
ঠিক আছে, সেকশন 30 allow.
বুঝতে পেরে গেছে আমার।
Yes, next matter.
Number 7. WBC 24 of 2019. We are discussing, my lord, I think all the papers we'll have to file paper books on WPCT.
It is your writ petition.
Is against the order passed by the Central Administrative Tribunal, the old matter of 2019, which has come back on remand from the Supreme Court.
You are for the original applicant.
My lord.
Let the paper book be filed.
Any interim, there is no, several orders have been passed, we
No,
find.
my lord, it was disposed in my favor. The writ
Which was disposed, the original application.
no, the writ allowed in my favor. Then, my lord, they approached the Supreme Court and remanded back.
Then the matter to be heard.
This is the third or fourth round of litigation.
So since the Supreme Court has remanded the matter back,
Yes.
so matter needs to be heard. When it was remand was passed,
December only, man.
No direction,
November or December.
19 November 2024.
Yes.
no request to dispose it of within any time. Only simple department.
Honorable Supreme Court has not fixed anything.
Go ahead, my lord. No request. My lord. Only remarks.
Yes, record an order. Writ petition is taken up for consideration in presence of the learned advocates representing the petitioners and respondent. When the learned advocate representing the petitioner has prayed for leave to file paper book. Stop. Next paragraph, let paper book be filed by 4 weeks. Let paper or 2 weeks, Supreme Court remand matter. Let the paper book be filed by 4 weeks and copy of the paper book be served upon the learned advocate representing original applicant / respondent by 7 days thereafter. Next paragraph, list the matter under the heading hearing. Supreme Court on 20th March 2025. 4 weeks and 7 days. Who is your senior? Where is he?
Due to some personal difficulty, he lost the person.
Not today. Next matter.
Next matter also.
Yes. Next matter also said not today. Come on.
by way of affidavit.
Your opposition by 2 weeks.
My lord. No, my lord, we'll file.
When your examination comes, March.
March.
Date fixed.
Not yet fixed, in the month of March. They have said in the month of March.
At the time of court, learned representing. That's how it is that we have to- because the price of the market on the- that- but the university examination. After getting this, comments, comment from what about the- that comment right March
Number 4 and 5.
have you want to file an affidavit in this matter?
In the item number 2, I have filed.
One is going to.
Yes, you want to file an affidavit.
Not this,
In the
Yes.
administration, they
Yes.
file, you are representing administration.
yes.
And medical college. Yes, what I was dictating. To file affidavit in opposition, stop. Let let affidavit in opposition be filed by 19th February 2025 with an advance copy upon the learned advocate representing the petitioner. Stop. List the matter under the same heading. List the matter under the heading. List the matter under the heading hearing on 20th February 2025, subject to convenience of the bench. Give your appearance, enter your appearance.
Obliged.
Item number 2.
This matter can be disclosed in the manner that we mentioned. The petitioner, she participated in the first year MBBS university examination. She was declared failed, Your Lordship, on the ground that in terms of the notification published by the National Medical Council, Your Lordship, on 1st August 2023, she cannot be declared passed. My case is that there was a notification on 1st August 2023, but there was another notification on 1st September 2023, whereby the 1st August 2023 notification was amended and the result was pronounced on 11th September 2023. My argument was that the day when the result was announced, on that particular date, the notification of 1st September 2023 should be made applicable, which has in fact amended the notification dated 1st August 2023. This was, if that is done, I will be passed. Now, Your Lordship.
Now, you are referring to two notifications, one dated
1st August 2023.
and the second one is August.
1st September 2020.
1st August, then 1st September
Yes,
2023.
yes.
It is NMC notification.
Yes.
Now, when the result published,
11th September 2020.
11th September.
2020. Now, Your Lordship, see.
So this benefit of amendment, this should be extended to you.
Similar issue was there, exactly the same situation before the Madras High Court.
Yes.
Single bench, the students won the case. The application, that 1st September 2023 notification has to be applied and they were declared passed. They went to the division bench. Now division bench has also passed the order in favor of the students. So I am seeking benefit of the judgment.
What is this notification?
This is a notification laying down the criteria to declare the student passed. How that the marks have to be calculated, in which manner it is to be calculated.
So demonstrate this before this.
Yes, yes.
Yes.
same issue was involved in item one or earlier round in item one.
But they.
But what happened is that those students, when they took advantage of because this petitioner here gave the fifth attempt, so there was no scope for any
In
further.
this matter,
In this matter, the fifth attempt, the others were not the last attempt. So they gave those repeat attempts and passed in the usual course. So that is why this issue became not relevant in those cases, and those writs got disposed of. And the fresh writ was passed because of their attendance issue, that other thing which my lord has already.
in item number 1.
Item number 1. But item number 2 is the writ which survived because this petitioner was declared failed on the fifth attempt. So there was no scope. Now, if she takes the benefit, according to the petitioners,
That was the last attempt.
last attempt. So if she gets the benefit of this notification, then on the basis of this, she would be declared pass. That is their argument.
Yes, because that notification says that fifth attempt should not be should not be treated as a last attempt.
Yes.
No, no, no.
No, no.
Passed and.
She's passed. So if she's passed,
Apply.
then she's passed.
Passed.
Fifth attempt. If
Its criteria has been
So
changed.
why you were declared failed in the
Because direct the notification, unamended notification.
1st August 2023?
Yes.
1st August, what was there in that notification?
Show you.
Yes.
Come to page number 163. This will be clear.
Just a minute. 163.
160. Here on the right side is the present. That is person.
This is the amended circular
Amended.
notification. Just a minute. Which one is relevant? So far, this notification is concerned 1st September 2023. One is previous provision was that a 50% marks in aggregate. Now it has become 40%. This is relevant, or the 50% in both are relevant. Now it has brought down to 40%. Now the second part of this notification is 50% has to be obtained in theory and practical separately.
Yes. In theory and in practical.
Now there is a ratio which has been laid down. Right. 60 to 40. Now, if this formula or methodology, which is contained in the amended provision as provided in the right hand side of the table, is applied, in that case, he will be declared successful.
That appears to.
So
The only issue is whether it can be applied retrospectively. So the NMC, my lord.
No, that's why I have asked Ms. Nag that when the result was published. The result was published as it has been stated 11 September, and this amendment came into effect on 1st September. 1st September. Yes.
Their contention we have written to them, in fact, to seek a clarification. They clarified that it will not, what the relevant point is when the exam was given. So after the notification comes into force, only this would apply to those examinations which are given after 1st September.
The examinations which are held after 1st September. That is the stand of NMC.
And that was subject matter of proceedings before the Madras High Court.
And the Madras High Court has.
So I have one judgment which has held that it won't apply.
No, that is completely a different one. This is exactly the same one. I'm placing it.
Now, whether any challenge has been laid against the order of the Madras High Court before the Honorable Supreme Court, Mr. Sivabalan, whether this order is under challenge before the Honorable Supreme Court, because this has got persuasive value so far this court is concerned. It is not binding upon me. Now, if the Supreme Court issue is pending before the Supreme Court, then we need, then I am required to wait for the verdict which will come from the Supreme Court. Which the judge, division bench judgment of Madras High Court 23rd January 2025.
Yes. Relevant paragraph is
This judgment.
P11 may be seen, you know.
P11.
P11 is the relevant paragraph. First judgment, P1.
Yes.
P1, not 11, page number 11. 11.
This is dated 23rd January 2025. Which paragraph? Find that almost all the reports are. So those students whose results were not published by 1st of August 2020, that is the old notification.
What is given considered for the benefit of the students.
When two interpretations are possible, the weaker section should get the benefit, and the beneficial interpretation should be in favor of that section. Yes, what is its main grievances against you? What is your stand?
We have stated that the exam was held before the notification.
Already the Honour Division Bench of Chennai Madras High Court as well as the Kerala High Court has passed orders in favor of the students. Now, whether these orders are under challenge.
I will give you a dimension. And in Kerala, you know, they have already implemented the order. Those students have already been declared pass.
Pass.
I'm just placing this judgment, my lord. This takes a different view from the Kerala High Court. Just placing it, or maybe it is not a
Facts are different.
Here, my lord, the issue was whether it applies prospectively or not.
The result already declared. as I remember, February examination took place and in July, August.
In Kerala matter.
You see paragraph number 18, page 35, keeping in mind the limited.
Paragraph number,
18 mind.
just a minute.
According to the only when it's found. Right.
Yes, paragraph 18.
Keeping in mind the limited role available to the writ court, I shall consider the impact of decisions that have been referred to by counsel for the petitioners already stated. Judgment in such and such cannot be applied. Judgment in such and such can be applied only if the court finds that there is element of bad governance in applying the revised valuation criteria prospectively. I do not think there is any bad governance involved in these cases. The expert body, after a relook into the valuation criteria, made certain amendments to hold that the amendment would apply to all students who are undergoing MBBS course, which extends to such and such more than 4 years, will
Necessarily be.
The norms cannot be applied to students who have already taken the examination and whose results have already been announced. That would mean a redoing of the entire exercise which was done earlier. This court in exercise of extraordinary jurisdiction under Article 226 cannot create chaos in the entire country by declaring the norms will apply retrospectively. This court cannot remedy every hardship. It may be true that a revised criteria had applied. Several of the petitioners would have passed their examinations earlier. However, that cannot be a reason to say respondents have gone wrong in implementing the revised guidelines prospectively. As held by the Supreme Court, this court must keep its hands off if the issue is within the domain of experts. Court not being an expert body to decide on standards of education and examination is also not competent to determine whether there is any manifestly unreasonableness. Petitioners do not have a case that a decision to liberalize the evaluation criteria itself is unreasonable. They are only agreed since liberalized scheme is not being applicable in their cases. Already observed, this court cannot direct retrospective operation of the guidelines and create chaos. When a retrospective operation cannot be declared, necessarily it follows that benefits cannot be extended to the petitioner before this court alone. Unlike the choice of a date of implementation of beneficial pension scheme, the issue involved in these cases is refixation of standards of the examination. Refixation of the standard, mainly because it is more liberalized, does not lead to a situation that it should be made applicable to all students who are undergoing the study. There is nothing unreasonable in fixing a date for implementation of the liberalized scheme. The decision in such and such cannot be made applicable. That was the case where this court held that fixing a mandatory minimum period, separate residence such and such a situation does not. It is difficult to conclude there is any discrimination between the petitioners and other students who appear for the examination after the introduction of the amended criteria. So, my lord, here the court has said that there is nothing wrong with the executive
To fix up a date.
fix a date for with effect from which the amended scheme will be applicable, and my lord will see.
And it has got no retrospective effect because that would lead to a chaotic situation.
And kindly see the.
But where is the interpretation or observation with regard to the issue as it has been decided by the division bench of Madras High Court? The issue is whether a cut-off date can be fixed for extending the benefit of amended circular.
Therefore, here the court is saying that here that they will not interfere with the cutoff date which has been fixed by the NMC, where by not the cutoff date. The cutoff date fixed by the NMC, my lord.
1st September 2023. But if the result is published after the cutoff date.
Here the court has said what is relevant is the date when the examination is taken. As per the Kerala High Court. Single bench, but the same Kerala High Court,
Yes.
single bench judge, the same judge had passed another decision which is being relied upon by you. Kindly see para 10 also of this judgment. This is from.
Since one division bench is before me and the issue is student issue. And furthermore, if the amended provision, amended notification is applied, student would be declared successful. Let the views expressed by the division bench of Chennai High Court be accepted, and let the student be declared successful.
Page 32 of that Kerala High Court judgment, just to assist what the.
Yes.
Court says, para 10 says the counter affidavit. for-
Just a minute, para 10.
Page 32.
Just a minute. The counter affidavit, yes.
Counter affidavit further says that after publication of guidelines, queries were received from various stakeholders as to the retrospectivity of exhibit R1B. It is stated that UGNEB had issued a public notice on 3rd October 2023. This is the same thing which has been annexed here also, stating that retrospective effect cannot be given. Exhibit such and such is a copy of the said public notice, which is then submitted the petitioner who have taken the examination before publication of exhibit R1B guidelines cannot seek the benefit of the guidelines. It is asserted in the counter affidavit that crucial date for claiming benefits as per exhibit R1B guideline is date when the examinations commenced and not the date on which the results were published. So my lord, if my lord.
It goes against the petitioner. So far, this matter is coming.
Because if my lord sees the same page 165 is the same public notice, which page 165 is a repetition. So my lord will see, this is the public notice which is issued by the NMC. Where
Page
165. my
of the
lord.
writ petition.
Yes, sir. Immediately after that, first September notification. So my lord, 165. This is in continuation of new amendment in CBME guidelines issued through corrigendum bearing such and such dated 1st September 2023, where a new amendment was introduced to CBME guidelines. Read at page number 58. After thorough consideration of the subject matter, it has been decided the retrospective effect in this connection is not possible. So this is in further substantiated in the counter affidavit, which is discussed at para 10.
This creates a hindrance so far the claim of the petitioner.
So far as the claim of the petitioner, because the date of commencement of the examination is before the coming into force of this notification. Because my lord, the fifth attempt, my lord, in this case, fifth attempt up here. The fifth attempt, my lord.
That a retrospective effect in this connection is not possible.
July 2020, examination is held in July 2020.
No, the fifth attempt.
Result was
It has been
announced.
decided that a retrospective effect in this connection is not possible.
That point was not the point in that case. The result, because date of result I'm not finding from anywhere in this judgment, but it appears that their examination was held much before the amendment.
No, it's a date of commencement of the examination.
That
It
is,
is not.
that is the case of the.
It has been decided that a retrospective effect in this connection is not possible after thorough examination.
So
Now here in this case, yes,
no, I'm not
admitted
saying
provision is this that the examination was held
commenced.
prior to
Commenced. It was
examination.
commenced in the sense.
Examination was held, not only commenced, but the examination was concluded prior to 1st of September 2023.
Yes, ma'am.
2023.
Yes.
Now, whether the petitioner will get the benefit of 1st September
So,
2023
see,
notification or
that
not,
you-
since the result was published
Yes, so,
thereafter.
no, I'm only submitting my lord.
Another thing which this court is also considering, if the retroactive operation of this notification as it has been held by Kerala High Court is as well as by the division bench of Chennai High Court would create a chaotic condition. But if if the result is published after 1st of September 2023, is there any scope of creation of chaotic condition?
So, my lord, the view of the Madras High Court is that the date at which it should be pegged is, my lord, the date of the declaration of the result. And the view of the Kerala High Court in this decision is that
Commencement
of the examination is a relevant date. So, my lord, if an examination is commenced after 1st September 23, you may get that. That is the view of the authority also. NMC has also taken that view, which is supported by para 10, which is a discussion on their counter affidavit. So, my lord, your lordships, my lord, Consider, my lord, the question is, there are two different courts, my lord. One is Madras, Division Bench of Madras and Single Judge of Kerala.
You know,
So my lord will
what's happened, I'm submitting. The facts are different. In the same judge has passed the order election. Same judge who has declared that the result which was declared on 11th after in September, to that 1st September will be applicable. Same judge has decided this issue. Why? Because these students are different students. They were not of the same batch. These students wanted that for all times to come, the amendment should have a retrospective effect so that they can be declared passed. Their examination was held in February.
Even if those students were results were published,
Yes, it was general one.
the effect would be topsy-turvy.
Yes, that is the reason why this judgment was passed. Because they.
Only the facts of the case which was considered by the Kerala High Court.
Yes, Your Worship. And we see that their examination was held in February and May.
And the result was published prior to 1st of September 2023.
Here is this particular judgment. Not at all when the result was published. That was not an issue. They came blankly before the court saying that the notification should be given retrospective effect.
Just a minute.
The result was not at all the point here, what I'm finding. I didn't find it. Result from the date.
Paragraph 3 may be seen.
Result the date thing. Date is important.
Kindly see para 3. Para 3 at page 28. Declare, mistaken as declare the supplementary examination of 19 days.
Of the regular examination.
Most of the students 151.
Okay.
She was
Yes,
declared
it's
failed in the.
before that, because
Just a minute.
Got 154 marks in it. What
yes, we got it.
She was. Young she went to the prior to me about passing the examination. Then it went to the subject.
But in this case, Miss Nag, there is one difficulty, as it appears that applying 1st of August 2023 criteria, petitioner was declared unsuccessful, which prompted the petitioner to appear in supplementary examination. It was a 5th attempt, as you are saying. So this 50%, this criteria of 50% of marks in aggregate, that could not be achieved by the petitioner. That could not be achieved by the petitioner. Applying previous circular, which resulting in participation of the petitioner in supplementary examination. Now, while in the supplementary examination, petitioner was 5th attempt, petitioner was declared unsuccessful, applying the old criteria. Now, your contention is this: if 1st September 2023 criteria is applied, then she would have been declared successful. But already the petitioner appeared in the supplementary examination on application of the old criteria.
Your Worship, that was the issue before the division bench. Same case. They were also in the fifth attempt. All those students were also in the fifth attempt. Here what happens, one examination is held. There are 3 subjects. A person is declared passed in one of the subjects.
Otherwise, if the new criteria which has been introduced under 1st September 2023 notification would have been applied, then petitioner might have been declared successful in previous attempts.
No, Your Worship.
But that was not in existence prior to 1st of September 2023. It came into existence, but prior to that, applying the old criteria, already petitioner was declared unsuccessful. He, as a result whereof, petitioner had to appear in the supplementary examination.
Yes, Your Worship. Yes. Same case is there for the others also.
Only advantage that the petitioner has in this case is that in this case, the 5th attempt, the mercy attempt result was published on 11th September 2022.
That is after 1st of
That
September.
is the only good fortune for this petitioner to say that.
This petitioner, all petitioners of Madras High Court also, the same position.
Now, if in the 5th attempt petitioner is declared unsuccessful applying this old methodology of 1st of August 2023, which was prevalent prior to 1st of September 2023, then what course was left open to the petitioner? Again, he or she would.
Fifth attempt now.
And
That is the last attempt.
Fifth attempt also. Fifth attempt also.
this is the end.
No, it's also the 5th attempt, my lord. Medical student first year, 5th attempt, my lord. It's not as if that. But my lord, it's a question which your lordship will decide, my lord. But just to be fair to the court, my lord, para
Somebody is
5.
passed, Your Lordship, if somebody is passed applying the regulation, then she is passed, Your Lordship, whether it is 5th attempt or 1st attempt. That is
No,
immaterial.
that's right. Kindly see para 5 of
And this particular, just a minute, this particular judgment which has been raised by my learned friend, there the result was announced on 10th May 2023. That is the reason why it was the retrospective.
Where from you are getting this?
page 29, bottom of the page.
My
Appears,
learned friend only has showed me this one.
that appears to be the case, at least in case of one of the petitioners. I don't know with the rest whether it is not clear.
He bunched. This was a bunch.
Paragraph 5.
Yes,
Para
correct.
5,
Last
I
three
will
lines
see.
will be seen.
Just a minute, petitioner to undo this question.
Kindly see the last last lines.
Just a minute. Examination in February 2023 and result May 10th May 2020.
That appears to be the case.
Those were the bunch of cases, Your Lordship. It was number of students are approached the court. And they was.
And let me rely upon the judgment of the division bench
My lord,
of Chennai High Court.
my lord.
Please give me the facts. Otherwise, petitioner will be debarred from studying MBBS course.
But she's under, let them at least come back if SLP is preferred, man. She's.
Yes, Miss Nal. What are the facts? What are the facts?
She's attending classes under interim orders of the school.
What are the facts?
Yes. Petitioner, she participated in the examination of first year MBBS university examination. The theory was held in July 2023.
Just a minute. First year MBBS course,
Theory was held in July 2023.
MBBS first year examination, final. Theory in July,
2023.
yes.
And practical in the first week of August 2020.
Yes,
Result was pronounced on 11th September 2020. This is with regard to the fact of the petition.
a result was pronounced on 11 September 20, but that is the fifth attempt. But prior to that, when the examination, first examination was held,
In our opposition para 3, we have mentioned.
you have filed your opposition.
Yeah. Then
It.
And this is only in this one subject area. Others she has already passed.
our stand is paragraph 3 and examination comments we have mentioned at paragraph number 7. 7.
Paragraph 3 you have stated.
Our stand is that therefore if the exam began before 1/2/2023, regardless of when they conclude,
Just a minute, that before travel. Sorry. Central. First of. For the pension is treated as single. Even if part of or some custom. They will be considered as yes before that. Some sense of once. 1st September 2023 was the exam, therefore if exam began on 1st September 2023, this was the first attempt, 1st September 2020.
on started on 7/7/2023 of the petition, paragraph 7.
No. What was, when the first attempt, when the first September.
Batches of 2019 finals.
January 2021 first attempt. Second.
Just a minute. First attempt, then
July 2021 second attempt.
July 2021 second attempt.
Third attempt March 2022. Fourth, 2022. One.
Just a minute. October 24th attempt. And fifth,
Like, she is not.
that was published in 11th of September, on 11th of September. Just a minute, 5th July 2023. July 2023. Fifth attempt. So your contention is this, that therefore if exam held on 1st February 2023, so far the fifth attempt is concerned. Fifth attempt, it was in July 2023. Therefore, if examination began first, why you are saying 1st February 2023 in that event?
The exam began.
It was in July 2023.
Paragraph 7 we have mentioned.
Regardless of when they found.
It must be 1st July, not by mistake 1st February.
So why you have stated in paragraph 3 that the CBME guidelines dated 1st September or 1st August 2023 won't apply. Because we are considering applicability of 1st September 2023 application guideline, not 1st August 2023 guideline.
But it was by way of amended by way of foreign interpretation.
Actually, first August 2023.
Is the parent notification that was amended.
And prior to also the number of notifications are there. First August 2023, they have amended, and that first August 2023 was
Undergone further amendment.
agenda on 1st September 2020.
Petitioner is a student of MBBS course which commenced in 2019. Stop. First year final MBBS examination in which petitioner participated was held in January 2021, where petitioner was not declared successful, which resulted in participation of petitioner in subsequent supplementary examinations on 4 occasions, which were held in July 2021, March 2022, October 2022, March 2022, then October 2022, and July 2023.
In these examinations, there are 3 subjects, 2 she have already passed.
Stop. It needs to be recorded herein that in these examinations, in 2 subjects, petitioner was declared successful, but in 1 subject, petitioner could not pass. Stop. By presenting this writ petition, what are the applications for? What are the
Sitting in the classes for 2nd year. And
all are pending or disposed of?
That is similar to the writ petition filed in the first one. That will again have to.
I have to file it again, because this is the main disposal of a main matter. So for that, I will take liberty and that can be disposed.
So that you can participate in the 3rd year examination.
You have to file a fresh writ.
Yes. Keywords. In presenting this writ petition, prayer is made to declare the petitioner being a successful candidate on applying methodology as contained in notification dated 1st September 2023 in the form of corrigendum issued by National Medical Commission, amending certain provisions of undergraduate medical education rules. Stop. National Medical Commission within bracket hereinafter referred to NMC. It is also submitted that there is a notification dated 1st August 2023 in connection with graduate medical education norms, which was further amended with a said notification dated 1st September 2023 And according to the petitioner, if the methodology of the last notification dated 1st September 2023 is applied in the case of the petitioner, he or she would have been declared successful in her 5th attempt to clear first MBBS final examination, first year MBBS final examination. Stop. In support of such contention, reliance is placed on the judgment of a division bench of Madras High Court dated 23rd January 2025, within bracket, or in the matter of controller of examination, in the matter of the controller of examinations, comma, Pondicherry University, comma, Pondicherry, versus Megha Maria Jo and others. Stop. Another limb of submission made on behalf of the petitioner is the relevant notification was issued on 1st September 2023, whereas result of the petitioner was published on 11th September 2023, which whereby a right is accrued in favor of the petitioner to get the benefit of state notification dated 1st September 2023. It is also submitted that this is strike of this is. It is also submitted that petitioner participated in the supplementary examination of July 2023, which was her 5th attempt, and if she is declared unsuccessful, petitioner shall be debarred from pursuing her or pursuing MBBS course or pursuing MBBS course. Next paragraph. The case made out in the writ petition is opposed by the learned advocates representing NMC and respondent numbers 2, 3, 9, and 10, being the Medical College Authority, namely Andaman and Nicobar Islands Institute of Medical Sciences, Port Blair. Mr. Chakraborty, next paragraph. Mr. Chakraborty, learned senior advocate representing the medical college, submits that examination was held in July 2023, that is prior to issuance of notification dated 1st September 2023, which prevents the petitioner from getting the benefit of the methodology as contained in this said notification in order to declare the petitioner as successful candidate. Stop. According to the Medical College Authority, mere declaration of result on 11 September 2023, which is after the date of relevant notification, that is 1st September 2023. Does not make the petitioner eligible to get the benefit of such notification. Precisely the same, or precisely it is also the stand of NMC as pointed out in reference to the relevant paragraphs in the affidavit in opposition filed in this matter. Stop. In support of such contention, reliance is placed on a judgment of a single bench of Kerala High Court dated 24th May 2020, dated, what is the date of this judgment? Dated 24th May 2024. In the case of Navanit V versus Kerala University of Health Science, wherein according to the respondents, it has been held in paragraph 18 of the said judgment that norms cannot be applied to the students who have already taken the examination and whose results have already been announced. Stop. It is submitted that it is submitted in reference to the judgment in reference to the judgment in Navnit Supra that after conducting after participation in the examination, issuance of notification dated 1st September 2023 cannot make the situation different on ascribing retroactivity of the said notification dated or on ascribing retrospective effect of said notification dated 1st September 2023, which would lead to a chaotic situation. And the college authority vis-a-vis university in that event would be required to change the results of many students and settled positions would be unsettled. Next paragraph. In consideration of the issue involved in this writ petition and taking note of the judgments relied upon by the learned advocates representing the parties, this court finds that the petitioner, though participated in the supplementary examination held in July 2023, which was her 5th attempt. But the result was declared on 11 September 2023. That is after issuance of corrigendum dated 1st September 2023. Stop. Question arises for consideration whether declaration of result after the said corrigendum dated 1st September 2023 would inure to the benefit of the petitioner in declaring her as successful candidate or not. Next paragraph. On examination of the issue, it appears that in Nabnit Supra, a single bench or a coordinate bench of Kerala High Court expressed view that the effect of said notification dated 11 September 2023 need not be extended if examination was held prior to the date of such prior to 11 September prior to 1st September 2023, and if result is published now prior to 1st September 2023, prior to 1st September 2023, strike of rest of the part strike of rest 1st September 2023 in the context that the examination was held in February 2023 and the result was published on 10th of February 2023, the 10th of May 2023. Stop. Therefore, in the facts of the case, which was considered by the considered in Nabnit Supra, it is found that not only examination was held prior to date of prior to the date of relevant or prior to date of corrigendum dated 1st September 2023, but the result was also published before 1st September 2023, and in the event benefit of said corrigendum dated 1st September 2023 would have been extended in that case. Certainly, a result would have been or effect would have been topsy-turvy. Next paragraph. But in the present case, though examination was held prior to 1st September 2023, that is in the month of July 2023, but result was published on 11 September 2023 after corrigendum, after the corrigendum was issued on 1st September 2023. Stop. This court also finds supports from the observations made by the division bench of Madras High Court in controller of examinations, Pondicherry University Supra, wherein in paragraph 15 it has been held that when two interpretations are possible, courts are expected to lean in favor of weaker section, and students were found as weaker party in between the two litigating parties in the present, in that case. Stop. This code, no, stop. The interview petition which was subscribed by the division bench of Kerala High Court, division bench of Chennai High Court, needs to be relied upon in the present case in the backdrop of facts that the result was published after the corriendum. Result was published on 11 September 2023, which is after the date of corriendum, that is 1st September 2023. Stop. Moreover, if petitioner is declared unsuccessful in her 5th attempt, in that event she would be debarred from prosecuting her studies under MBBS course. Stop. From the submissions made on behalf of the respective parties, it also does not appear that if that in the event favorable interpretation is ascribed. So far, corriendum dated 1st September 2023 is concerned, which ultimately would declare the petitioner to be a successful candidate in connection with her participation in the examination, in supplementary examination held in July 2023, that would not lead to a chaotic situation. Or it will not unsettle the settled position. So far, declaration of results of supplementary examination which was held in July 2023, is concerned. Next paragraph. In view of aforesaid scenario, this court directs concerned respondent authorities to give benefit of corriendum dated 1st September 2023 in favor of the petitioner, and on application of such methodology as contained in the said corriendum, if petitioner is found successful, she shall be declared a candidate who has passed who passed supplementary examination held in July 2023 by fortnight from the date of communication of this order. Stop. Which application is kept pending? Acha. Next. Connected applications, if pending, are also disposed of, granting liberty to the petitioner to take steps in accordance with law for taking necessary to take steps in accordance with law if so advised. This is also under Pondicherry University.
Now, my lord, Pondicherry University has been replaced by Netaji Subhash Chandra Bose.
Now, from which date? Because there is another aspect in Madras High Court matter, those students are also studying under Pondicherry University. So there will be a creation of two groups. One who would get the benefit of the division bench judgment of Madras High Court, and if I dismiss this writ petition, then that similarly circumstanced candidate under the same university would be declared unsuccessful candidate. Still Pondicherry. Another before this disposal, where I have give my reasonings, add another paragraph. If today benefit of corriendum dated 1st September 2023 is not granted to the petitioner, a situation would be created that the students who got the benefit by virtue of the judgment of the Honorable Division Bench, or who got the benefit of corriendum dated 1st September 2023 by virtue of the judgment of the Honorable Division Bench of Madras High Court past in Controller of Examination, Pondicherry University Supra, who already declared successful, but in contradistinction thereto, the petitioner who is undergoing MBBS course under same university, that is Pondicherry University, would be declared unsuccessful on would be declared unsuccessful. Stop.
After giving the marks, because marks has been projected even before the single bench and division bench. And the Madras High Court has exactly applied the collegium. And Madras High Court has found that they are passed. Similar is the case of the petitioner, because the ultimate decision, I have to come to another round of litigation. The reason is that second year examination, I have already participated. They have not declared the result. Now I have to wait 15 days for the declaration of first year, thereafter second year. But here you also have to looking into the same type of marks we have also got. If we apply it, you know, the kind is in a final direction.
Let
Hence,
it be left, my lord.
just-
Time can be reduced, my lord. Let
Just-
it be one thing.
Hence, these writ petitions are dismissed. Writ petitions will stand allowed, and the mandamus is issued to the respondents in the writ petition to declare the petitioner and WP as passed in first year at all. Because if you not, I can satisfy your lordship with my marks and the marks which has been obtained by these.
That is in connection with your second year examination.
First year, I am telling. They have also come marks if I show by where this honorable court also can find out that we are passed. So what I am submitting, your lordship, same type of direction should be issued to the authorities to declare me pass in the first year examination after looking into the marks.
No, my lord, we strongly oppose that.
But I have already directed the authority to declare the petitioner passed.
Calculate, there will be.
This presumption of malafide, my lord.
That is
No,
what
that is not
I have
fair.
to come again, I know about that.
No, madam, that is not fair.
Again,
They cannot.
again, the thing is that we have to again.
No, no,
Yes.
madam, why is such a presumption being drawn? Authorities are expected to act fairly.
Yes, disposed of.
Marks are almost exactly the same.
So that's why there will be two groups under the same curriculum under Pondicherry University. One group will get the benefit of division bench, judgment of division bench of Madras High Court, and if today dismiss your petition, then the petitioner will not get the benefit of that corriendum dated 1st September 2023. It's a class within class. That is what I have held in my last part of dictation.
If you-
Yes.
3, 37 of 2025,
Not today. Next.
Four, 45 or 25.
Yes. Yes, what is the matter about?
Background of litigation. Finally comes to your page number 56. What are the responsible for?
So correction of revenue record is rejected. Failed. Now, is there any provision, is there any scope for passing an interim order in this matter? Where is the final order which you are challenging?
Page number 58. For the honorable, the last occasion, directed deputy commissioner to supply those documents which they are relying. So it was given to deputy commissioner, but despite that, again, they have done the same.
So let it be decided on a affidavit. By presenting this writ petition, inter alia, challenge has been laid against order dated 16 January 2025 passed by Deputy Commissioner, South Andaman. Stop. By the impugned order dated 6 January 2025, prayer of the petitioner for correction of land records has been spurned. Stop. Next paragraph. Having perused the impugned order, this court finds that the issue needs to be decided on exchange of affidavits. Next paragraph. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Next paragraph lists the matter before the next available circuit after the time fixed herein above for exchanging affidavits.
Item number 5. What be 47 of 525?
I am appealing for the petition. Here I have served all the respondents because Union of India, there are 2 respondents and leadership of service is also filed.
Yes.
I am not seeking for any interim order, but the presence of those officials of Union of India is warranted because, my lord, what happened, my lord? I am a farmer, my lord. I supply.
Have you served notice upon Union of India?
Yes, my lord. Leadership of service I have
I
filed.
am appealing for the respondent number.
Well, not today. Let me see if tomorrow somebody appears on behalf of Union of India. Not today. Today I am not passing any order, Mr. Chakraborty. Not today. If somebody appears, inform Mr. Tulsilal.
Yes.
Inform Mr. Tulsilal. Yes, next matter.
Natural resources, mines. Now, my lord, earlier the Andaman Nicobar administration from 1994 onwards allowed me to carry the mining, extraction of mining from the said land, which is allotted in mine. 2012, Mines and Mineral Rules came into existence in terms of the act. Once the rule came into existence, they denied carrying mining operation in my land. And they started floating public tender, and on the basis of tender, allocation was made to the successful bidders. Now, my lord, I taken out a writ petition on the premises that I am an owner of a land, and therefore you take royalty and allow me to carry the mining operation in the said land by taking the aid of judgment of Supreme Court in Tarsama Dekar. This is the solitary ground on which writ was filed, that I am the owner of the land. Now, my lord, here, as per the special law governing the affairs, we are not the owner. Entire property rests with the government under section 38 of the Land Revenue Land Reform Regulation. So, on that ground, my writ petition was dismissed, appeal and SLP, everything was dismissed. Only on this score, I have challenged it. Now, my lord, this is my second round of litigation. Now, my case is, my lord, earlier, prior to the mining rules came into existence, the permission was accorded in terms of 201 of the special law, that is Land Revenue and Land Reform Regulation 1966, whereby the government has an authority to allocate mines, minerals to any as per their guidelines or whatever may be. Now, my first ground in this writ petition is that after framing the mines and mineral rules, there is no embargo under the rules, whereby it prevents the government to enjoy the power which accrued under section 201. This is my first argument, my lord. So therefore, it can always be done. There is no embargo under the rules. Second, my lord, if they feels that it cannot be done, it cannot be done in that case, because that land is mines is there. If it can be done, then in that case you take back the land from me and allot me some alternate land in the same vicinity. Had if in the public auction which you are carrying, you put my land also in the same, and I am ready to pay whatever the.
So what is the stand of the authorities?
It's appearing, my lord. It requires an affidavit.
Have you obtained any instructions? But you have said that the first round of challenge failed in, then where is the scope of interference?
Only to this extent, my lord, the Tarsama Dekar judgment says if I am a owner of a land, in that case, I
Having minerals.
Having minerals, I pay royalty and I can extract the mineral.
That you are not interested.
No, that what level, my lord? They say that as per section 38 of the Land Revenue Land Reform Act, here the entire land rests with the government. Therefore, that preposition will not come into aid so far as my case is concerned. Only on that score it was rejected.
Now, what is the effect of that rejection?
That the effect of that rejection is that since I am not the owner of the land in terms of section 38, therefore I cannot play equity at par with the judgment of the Supreme Court, which says that a owner who is blessed with mines and minerals, he can extract by paying the royalty. That will not come to my aid. Now, my contention is that under
Since it has been held by the authority that the authority is the owner of the land.
seek that parity so far as that judgment is concerned. So that was the issue which was decided in first round of litigation. Now this round of litigation.
So after that decision, if that decision was upheld right up to Supreme
My
Court,
lord,
then what is the scope of further entering into the issue?
the issue was entirely different. This issue was not there. The issue is that first issue, suppose my lord, they are not allowing me to run the mines there. You take back the land. You take back the land, give me a land in the same vicinity. Second, under section 201, you accrued the right to allot it. And the mines and mineral did not cast any embargo upon you.
Who will file your affidavits? Matter is heard in presence of the learned advocates representing the petitioner and the state and you are all the respondents and the respondents. Stop. It has been jointly submitted that there is no scope for passing any interim order in this matter, and the issue involved in this writ petition needs to be decided on exchange of affidavits. Next paragraph. Let affidavit in opposition to this writ petition be filed by 4 weeks from date, and affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Stop. List the matter under the heading hearing before the next available circuit after the time fixed herein above for exchanging affidavits. Yes.
WPS 84 of 525.
Sir, I'm getting to. I have the respondent here, not the respondent. The petition's father was the original departed member. After the death of the original departed member, 7 children died. So it was, thereafter it was notated in the name of the children, thereafter subdivided. Now the difficulty is that Y number was given. It's like mirror.
Have you obtained the instructions?
It's pending. Pending. For extending.
Please your representation.
Permission for exchange of the land. The subdivisional official is the appropriate authority under the land revenue land reform circulation. They are the legal heirs of. They are brothers. Two brothers, their share, you have changed their survey numbers. Because position is different. The survey number is 292 of the 6 of the petitioner. 292 of the 5 is the brother's name. But
There are 7 years, as you have said.
the difficulty is only with regard to myself.
You have not added the other years.
Here we have given jointly by saying that 292 of the 6, which is recorded in my name.
But 2 brothers are also not party, only the petitioner. So how the decision can be taken behind the back of another brother?
Now the brother has also expired, legalized has been substituted. They are agreeing, my lord. That's why both are kindly receiving, my lord. Petitioner number 1 is the brother, petitioner number 2 is the petitioner here. Jointly, they have given the representation by saying that our land.
Just a minute. We'll come back at 2. No, it will be the first matter at 2 p.m. In the meantime, if it is possible, you take instruction. So you are praying for exchange of land.
As per the secret possession. Only the survey number has to be changed, madam. And it has to be rectified in the records.
And correction of records in connection thereto is whether it is permissible.
So both the lands, they are in possession and they're in.
Are under the same category or not?
They are also same, I mean, that's the.
So let the decision be taken, but granting opportunity of hearing to both the brothers. Yes. Yes, take down.
Now the one brother expired, madam, legal. Their name has already been substituted.
Petitioner by presenting this writ petition, comma, inter alia, comma, has prayed for exchange of lands and correction of records in connection thereto. Stop. It has been submitted by the learned advocate representing the petitioner that two brothers are holding two separate pieces of land or two separate pieces of land. Having bearing survey number 292/6, measuring an area of 0.5650 hectares, and another land bearing survey number 292/5, measuring area of 0.5650 under Ferrarganj, TSL, South Andaman. Stop. One of the brothers, by making stop. Both the brothers made representation dated 1st February 2023, which according to the petitioner herein is required to be considered by the subdivisional officer. Sri Vijaypuram, Tehsil, South Andaman, being respondent number 2. Stop. Next paragraph. Respondents are represented by learned advocate who has submitted since a representation is made for exchange of lands and correction of exchange of lands and correction of records thereto, comma, same may be considered in accordance with law by the respondent number 2. Next paragraph. Having considered the submissions made on behalf of the parties, writ petition stands disposed of, directing subdivisional officer being respondent number 2, concerned subdivisional officer being respondent number 2, to decide the representation by passing a rescind order by 12 weeks from the date of communication of this order, after granting opportunity of hearing to the petitioner and all other interested parties. Stop. The decision to be taken by the respondent number 2 shall be communicated to the parties by 2 weeks thereafter. Next paragraph. Urgent Xerox certificate copy. I have already said disposed of. Yes. Yes, next.
Question number 8, WPS 647 of 124.
Okay. The fight is between the revenue and the forest. What I see. I am in a reserve forest. In view of the ratio of the Supreme Court, there has to be an identification to be made whether I am in a reserve forest land and period of enforcement. It has been identified that I am residing there since 1978, prior to 1978. In that view of the matter, I am entitled to get regularization of the land.
So you have filed an affidavit.
They have to file report. They files it because they got the report.
But the petitioner is required to file an affidavit with regard to the report submitted by respondent number 2. Yes. So say so. So unless until you file a reply, but the coordinate bench has said it's an affidavit.
That's the thing.
Which is to be treated as exception to the report. Yes. At the time of call, learned advocate representing the petitioner has prayed for accommodation, further accommodation, to file a report or to file an affidavit, being an exception to the report filed on behalf of respondent number 2. Next paragraph. Time to file affidavit by the petitioner stands extended by 2 weeks. List the matter before the next available circuit. Next. Same. Next one. Just one after another. Land advocate representing the petitioner has prayed for land advocate representing the petitioner has prayed for extension of time to file affidavit in reply. Stop. Time to file affidavit in reply stands extended by 2 weeks. Stop. Next paragraph. List the matter before the next available circuit under the heading hearing. ওটাও আগেরটাও তাই করে দেবেন under the heading hearing. Previous matter, it will appear under the heading hearing. Yes. Next.
Item 10, WP 649 of 2024.
Same order as the first one. Item number 8. Under the heading hearing, it will appear. Next.
Item 11, WP 19 of 2025.
Will it run for the respondents?
It's a different matter. Yes. Sufficient. Next level of subdivision. So no scope of fine. What you have challenged?
Challenge the very action of the Tahsildar in initiating a proceeding. One point of time, the identical proceeding was initiated, logical conclusion was given. Again, for the second time, for the self-same facts, proceeding was initiated, which are challenged here.
Now, once it has been decided how the self-same cause of action, another proceeding can.
So on this count, the action has been challenged of the Tahsildar.
What action? What is the nature of action?
Completed a proceeding under regulation 104. They said that I have imposed a government land which was earmarked as footpath. But on the identical issue, Lordship already decided, everything has been decided. So they want.
Decided in whose favor?
Because proceeding was dropped. The proceeding was dropped. The adjacent plot holder, Lordship, at her behest, a complaint was lodged.
Now, whether the land in question is to be treated as a pavement or not?
No, Lord, it can't be. Because Lord, to see the maps which are filed with the petition, my land which I purchased and the land which the authority claims, it's too far. It can't be said, Lordship, that I have imposed land. So on that count, the proceeding was dropped previously. Again, on the self-same.
So no order was passed, only the proceeding was dropped. Now the similar proceeding has again been initiated. And the authority has decided, the Tahsildar has decided it is to be treated as pavement.
Yes.
That you have challenged.
Yes.
I record an order. During course of hearing, learned advocate representing the state, representing the respondents has prayed for opportunity to use affidavit in opposition. Next paragraph. There is no scope for passing interim order as it has been submitted by the learned advocate for the petitioner, respondent shall be at liberty to file affidavit in opposition by 4 weeks from date. Affidavit in reply thereto if any be filed by 2 weeks thereafter. Next paragraph. List the matter under the heading hearing after the time fixed herein above for exchanging affidavits before the next available circuit. Next.
Number 12.
Is for the petitioner. Not today.
number 30, WPA 32 of 2025.
It can be.
I am appearing for the petitioner in this matter.
New connection.
Application is pending for more than 6 months.
Give me a similar order, Stephen. No, this is different. This is different.
21 of 24.
There I made, I had to correct some parts of the order because different point was taken. You can do one thing, this virtual mode is to be struck, is to be struck. Yes. Don't follow the pencil notes. Only this part is to be struck off. And the rest of the parts will remain same. Only the date of application. Date of application 21st June 2024. In this case, 21st June. It is respondent number 3. Assistant engineer, respondent number 3. Same order disposed of. One after another, please. Wait.
Number 40, WPA 40 of 2025.
Lordship, I am appearing for the petitioner similar matter.
Respondent number 3 is the assistant engineer. Yes, 24 June 20. Disposed of.
Item number 15, WPA 14 of 2025.
Same lordship as respondent number 2.
And application dated 2nd December 2024. 2nd December 2024 application. New connection. And assistant engineer is respondent number 2. Disposal.
Item number 16, AP 14 of 2024.
We're on Friday. Adjourned till Friday. 7th. No order, 7th.
Item number 17, CPL 3 of 2025.
Contempt application. Arising out of the order passed by which court? Yes, must be single bench. Sugata Majumdar. Consider and this for the representation. Yes, you have not taken any decision.
Lordship is available. I don't know, my lord. I don't know what matters.
Oh, Justice Majumdar is available, right? So the matter is to be transmitted to the principal bench. Record an order. Yes. So that is to be corrected by the regular bench. I will not pass any order. That is to be indicated, pointed out by the bench, which bench will consider this contempt application. Record an order. This contempt proceeding has arisen out of the order dated 6th August 2024, passed by the Honorable Justice Sugato Mujumdar. Stop. Let the records of this contempt proceeding be transmitted immediately to the principal bench and be placed before the Honorable Justice Sugato Mujumdar. Stop. Next paragraph. A registry is directed to take necessary steps.
My lord, will-
Just a minute.
Item 80, CPN for 125.
Justice Mujumdar. Date of order is same. The date of order is 6th August 2024. Same order.
Item 90, WPA 297 of 2021.
Sir, I am the petitioner in person in this matter.
Nobody is appealing for the respondent. What can be done?
Yes, sir. Sir, I understand, sir.
Yes.
So I'll serve the copy again to them, to the respondents, and I'll file again the affidavit of service.
Now you have to notice upon all the respondents. Have you served?
Yes, sir. I have sent, sir. I'll send it again, sir. I'll send the copy of the petition again to them, sir.
Where is your affidavit of service?
Sir, I'll submit in 1 or 2 days, sir. I'll take some time because my health is not good, sir. I'll send some.
What is this? No, this is additional court fee. Where is your service of notice?
Sir, I'll send it again, sir. Give me some 4-5 days time, sir. My health is not good, sir. That is the reason. Because this matter is a old matter, sir. It is listed after so many years.
Where in this matter? Let me dismiss the writ petition and you take steps in accordance with law. Because
Sir,
on 14 January 2025, court passed an order.
sir, I'll serve a notice again to them. I'll send a copy of the petition. I'll submit the affidavit and service again, sir.
Why you have not served notice upon the respondents?
Sir, I am appearing in person, sir. I am not a legal person, sir.
Hearing person, I know. But this is a writ petition of 2021. Where is the service?
Sir, I'll submit the affidavit of service in due course, sir. Give me some 5 days time, sir.
At the time of call, petitioner who is appearing in person has prayed for accommodation to effect service of notice upon the respondent. Next paragraph. Petitioner is directed to serve notice enclosing copy of the writ petition upon all the respondents by 2 weeks and file affidavit of service on the next date. Stop.
Thank you.
This the matter before the next available circuit after the time fixed herein above for completing service.
Thank you. Thank you, sir. Thank you, sir.
Yes, next.
Item 20, WPA 220 of 2022.
I agree with the respondent.
As prayed for on behalf of the petitioner, hearing of this matter stands adjourned. List the matter before the next circuit under the same heading. Next.
Item number 21,
WPA 240 of 2022.
Time to file reply mechanism extension. This is a government under the petitioner is in Tamil Nadu.
So where is the petitioner? Who is appearing for the reply? You have who is appearing for the respondent? Who is your senior? The Sivawala. Last week also he has taken time in so many matters. Client advocate representing the respondent has prayed for accommodation on the ground of the. No, just strike it off. Accommodation has been prayed for on behalf of the respondents on the personal ground of the client advocate. Stop. As next paragraph, as prayed for, time to file affidavit and reply stands extended by 2 weeks. List the matter before the next available circuit under the same heading. After the time fixed herein above for filing affidavit in opposition. Yes.
22 and 23, my lord.
Same matter. You are who is for the petitioner? You are for the petitioner.
Mohammed Abis appearing for the petition, item 22.
Who is appearing for the petitioner?
Mohammed Abis, my senior member. 23 must start.
As prayed for on behalf of the petitioner. Hearing of this matter, as prayed on behalf of the petitioner, hearing of this matter hearing of this matter stands urgent. Next paragraph, respondents are represented by learned advocate. Next paragraph, list the matter before the next available circuit.
Connected matter also go.
Matters. 22, 23. Next.
Item number 24, WPA 314 of 2022.
My lord, in item 24, my lord, I am appearing for the petitioner.
Not today. Petitioner is not there.
For the petitioner.
Oh. Yes, yes. If you are for the petitioner, then what is your stand?
Respondent is not there.
We will not today.
Order challenging the order passed with the labor court.
Yes. So not today.
Fine.
Not today. Let me see if tomorrow it can be taken over or not.
Item number 25, WPA 862 of 2022 with item number 26.
Appearing for the petitioner, item number 25. In item number 26, my senior is appearing for the respondent.
Yes. Who is your senior?
That is for the respondent in.
So what is your petitioner? Yes. Where is Mr. Lal? But in the morning he was there. So far. As prayed for on behalf of the petitioner. So you are appearing for the petitioner in item number 25.
Yeah.
And in 26?
26 Lal is for the.
As prayed for on behalf of the petitioner in WPA 862 of 2022 and respondents in WPA 938 of 2022. Hearing of these two writ petitions stands adjourned. List the matters before the next circuit. Next.
Number 27, WPA 485 of 2023 with item number 28.
In this matter, my senior is appearing for the petitioner. I pray for next circuit.
27 and 28. No, it's
No.
29. 27 and 28. In both the matters, your senior is appearing for the petitioner.
This for you.
accommodation has been paid for on behalf of learned advocate accommodation has been paid for on the ground of the learned advocate representing petitioners in both the writ petitions. Next paragraph. Hearing of this matter stands adjourned. List the matter before the next available circuit. Next.
Number 29, WPA 593 of 593.
The next circuit.
You are for the petitioner.
I pay for one of the restaurants. इसके लिए तुम बता दो अच्छा तुम कुछ भी तुम right हो
What about the affidavit in reply?
I'm not feeling well, to be very honest, Your Lordship, so I could not prepare it. And there's remote chance that I'll get.
You are always agile and energetic. You are not feeling well.
So.
Human being.
Therefore, this court is not privileged. Time to file affidavit in reply stands extended on the prayer of the learned advocate representing the petitioner.
गंभीर बीमारी है
Stop. Stands extended by 2 weeks on the prayer of the learned advocate representing the petitioner. List the matter before the next available circuit. After the time fixed herein above for filing affidavit in reply. You entered your affidavit.
WPA 645 of 593.
With regard to position by the judgment number 2 and 4.
2 to 4.
The respondent is not by.
This.
I'm referring for respondent number 2 to 4.
Client advocate representing the petitioner has prayed for extension of time to file affidavit in reply to the affidavit in opposition filed on behalf of respondent numbers 2 to 4. Let such affidavit in reply be filed by 2 weeks. Next paragraph, list the matter before the next available circuit after the time fixed herein above for filing affidavit in reply.
Obliged, my lord.
Next.
WPA 703.
I'm appearing for respondent 1, 2, and 3.
Petitioner. Who is for the petitioner? Mr. Jaipal. Yes.
This can be.
Opposition, ma'am. Wait for time to file opposition.
1, 2, and 3 have already filed.
I'm appearing for.
You are representing which respondents?
Hearing.
1 to 3, you are Mr.
My lord. 4 and 5.
Subhawalan is appealing for 1 to 3, then
Yes.
4 and 5. Forest Department, you are seeking time to file affidavit in opposition. Learned advocate representing respondent numbers 4 and 5 has prayed for extension of time to file affidavit in opposition. Previous direction. Then why affidavit in opposition is filed on behalf of respondent number 1 to 3? Must be there was a direction.
Served on the forest department. Very well, my lord, may say extension. My lord, will file.
Has prayed for extension of time to file affidavit in opposition. Stop. However, petitioner and respondent numbers 1 to 3 are represented by learned advocates. Next paragraph. Time to file affidavit in opposition by respondent numbers 4 and 5 is extended by 2 weeks. List the matter before the next available circuit after the time fixed herein above for filing affidavit in reply. Next.
Obliged, my lord.
Number 32, WPA 883 of 503.
Lord, I am for the petitioner.
Yes.
Private respondent, Ms. Nag is appearing, but I don't think she's represented.
Yes.
It's a dispute between two private parties.
Demolition order was passed by the PBMC.
Where is the private respondent?
Let it be not today.
Not today. Come back to. Construction made by the private respondent is under challenge,
Demolition order was passed by the PBMC.
but it has not been implemented.
I approached this honorable court. Meanwhile, they filed the appeal before the appellate authority.
Let the private respondent.
Appeal was also dismissed.
Let the private respondents be represented. Come back tomorrow.
Number 33, WPA 887 of 203.
I appeal for the respondent authorities, my lord.
Petitioner,
Madam, I'm appealing for the petition. I'm seeking time to file an line now.
yes, place the record. Affidavit in reply, but last occasion there was an extension.
My lord.
How long this will go on?
Last time maybe.
Client advocate representing the petitioners has prayed for extension of time to file affidavit in opposition. Affidavit in reply. Stop. You are for the petitioner. However, petitioner, who is for the, you are the petitioner, right? Respondents are, you are representing all the respondents. However, respondents are represented by learned advocate. Next paragraph. Time to file affidavit in reply as a last chance, comma, stands extended by 2 weeks. Extension of time to file affidavit in reply is peremptory. Next paragraph. List the matter before the next available circuit after the time fixed herein above for filing affidavit in reply. Next.
Number 34, WPA 890 of 203.
My lord, I am appealing for the petitioner hearing. My lord, I am seeking time to file affidavit in reply.
Reply.
For 1 to 6 I have filed. I'm appealing for 1 to 6.
Respondent,
You filed a reply, Mr. Shivawalan.
Yes,
respondent,
Yeah, for respondent 7.
one to 6.
You were just saved from imposing to suffer an order of imposition of cost last occasion.
We have filed the opposition in the registry. It has not come here.
Client advocate representing respondent number 1 to 6 submits that affidavit in opposition has been filed, and the same is on record. You are not in, stop, same is on record. Learned advocate, next paragraph, learned advocate representing the petitioner prays for time to file affidavit in
1 week.
reply. Stop, let affidavit in reply be filed by 2 weeks. Stop, list the matter under the same heading before the next available circuit after the time fixed herein above for filing affidavit in reply. Next.
Item number 35. WPA 992 of 203. I'm appealing for respondent 1 to 4.
Lordship, in this matter, my seniors appears on behalf of the private respondent. I am praying for.
For the petitioner.
And they have used 2 separate opposition,
Yes,
one by the authority, one by the private respondent. Let me use my comprehensive reply as.
reply. So both have filed their opposition.
Yes.
Yes, ma'am.
You are for respondent number 1 to
1
4.
to 4.
Yes, and you are for respondent.
Respondent number 5. Private respondent.
Learned advocate representing the petitioner prays for time to file, press for time to file affidavit in reply. Stop. Let affidavit in reply be filed by 2 weeks from date. List the matter before the next available circuit under the same heading. After the time fixed herein above for filing affidavit in reply. Next.
WPA 917 of 103.
My senior is appearing for the
Not
respondent.
today.
Item number 37.
In this matter, my senior is appearing.
Not today.
37 and 38.
Come back tomorrow.
39.
I appeal for the petitioner.
Yes.
There was a direction upon the respondent authorities to file the affidavit in opposition. You have not used it as yet.
Paying for extension.
What is can 1 of 2024?
There was some interim order period.
No maintainability has been kept open.
At the time of admission.
Extra was not replicated for some time. That is. Not about it, John. Then for the school.
Here the petitioner happens to be
You are
Tenant.
representing all the respondents. There is a private respondent.
engineer madam is
Start is
representing.
okay. It'll be not today, my lord, in that particular case.
Well, not today. Come back tomorrow. Not today.
Petition is WPA 1 presented by Ms. Nath, should not be.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. However, respondents, you are for the respondent. However, respondents are represented by learned advocates. Next paragraph. List the matter under the same heading on Monday next, comma. 11th on Monday next 10th, on Monday next 10th February 2025. Stop. Next, however, it is made clear if in however it is made clear in the event petitioners go unrepresented, consequential order shall be passed on the next date.
Right.
Next.
Item number 41. WPA 1072 of 2023.
In this matter, my senior is appearing for the petitioner. Appearing for next circuit.
Why?
Due to some personal difficulty, the senior is not in a good
Not
state.
today.
Item 42. WPA.
Your senior is having personal difficulty in the second half and in the first half he doesn't have any personal difficulty. Tell your senior. Yes.
For the petitioner,
Yes.
they have given the opposition, but it contains all pages except page number 2. This was brought to the notice of my adverse side, and she has undertaken to give a copy to me.
Who is representing the respondent?
Now,
Not today. Complete copy has not been served upon. Yes.
Item number 43. WPA 90 of 2024.
Lordship, in this matter, my senior appears on behalf of the
Who
petitioner.
is your senior?
N.A. Khan, London advocate N.A. Khan.
Yes.
I am praying for not today.
Not today.
Item 44. WPA 93 of 2024.
In this matter, my senior is appearing for the petitioner. Pray for not today.
Not today.
45. WPA. Record order of 2024.
I am for the
But
official
appearing for the
response.
message appearing for the respondent number 4 and 5, seeking time
For
appearing to file in opposition matter.
You have filed your opposition, Ms. Das.
No, my lord. The dispute between the private respondent.
So you don't want to use any affidavit.
But the authority has passed the order.
My lord, I'll file, my lord. Even I'll be seeking time, my lord, for filing my opposition. If required.
At the time of call, learned advocates representing the respondents has prayed for time to file affidavit in opposition. Stop. Yeah, was there any previous direction to file affidavit?
My lord, there was date.
Next paragraph. Time to file affidavit in opposition stands extended by 2 weeks. Next paragraph. Affidavit in reply thereto, if any, be filed by 1 week, by 2 weeks thereafter. Stop. Next paragraph. List the matter before the next available circuit after the time fixed herein above for filing affidavits on extension.
Fine. Obliged.
Next.
Number 46.
And I'm seeking not today, my lord. Not today. I'm praying
Not today.
WPA 2024.
Lord, I am for official respondents, my lord, 1 and 2, I filed my opposition.
Who is for the petitioner? Who is for the petitioner?
Lord,
Where is Mr. Vijay Kumar? He is out of station. No, Vijay Kumar. Where is he?
I'll ask him to appear.
Well, not today.
Item number 48. WPA 224 of 2024.
I'm for the respondents, my lord, all the respondents. And I filed my.
Petitioner.
opposition. To file the reply.
Yes.
Ready?
This matter, my senior is appearing for the petitioner. I pray for not today.
Not today.
Item number 49.
49 to
31.
Yes.
Number 5 only.
My lord, I am for the petitioner, my lord. I am the owner of fishing vessel, 3 vessels. Three vessels, fishing vessel. The master, my lord, without any intimation to me, as well as to the fisheries department,
Affidavits are complete.
Private respondent is required to be added.
he was added, notice was served, but they are not appearing, not private respondent. The commissioner of fisheries from Chennai. No notice was served.
That's the matter.
If they are not appearing after service,
Further attempt.
why you are standing in the way? Don't say that.
Department of Fisheries and
I'm not asking any relief from you.
Don't quarrel amongst yourself.
No quarrel then.
Show me that you have served notice.
My lord, I filed affidavit of service.
When it was effected service. Opposition, you have filed opposition.
Yes.
I am not claiming anything from administration as well as.
I understand.
Number 5, 5.
Commissioner of Fisheries. But this notice is not addressed to the additional respondent, Commissioner of Fisheries, Chennai.
Commissioner of Fisheries, my lord.
Show me that you have served
One
from the affidavit in opposition, affidavit of service.
My lord, 1 second. Break of service.
This is another affidavit service.
My lord, I may
It is
be
not
permitted-
addressed to the commissioner.
I may be permitted to see that.
Yes, yes, it is not addressed to the commissioner. What permission, what he is scrutinize?
But I served, my lord.
Issue. Land advocate representing the petitioner is directed to serve notice upon added respondent
My
of 7.
lord, this may be taken up tomorrow. I will ascertain whether service was affected or not.
We will not today.
All three
Next.
matters.
Yes, not today. Let it be on Thursday, not Thursday, Friday. All matters cannot be placed tomorrow. Friday. Yes,
Item number 52. W 300 of 134.
I'm appealing for the respondent authority.
yes.
I'm taking time to file affidavit replying, my lord, in this case.
Find it out whether you have served or not. As per the code. But previous occasion also you prayed for time. But affidavit in opposition has been filed. Yes. Why you are not filing affidavit in reply?
My lord, 2 weeks time may be gonna be fine.
As a last chance, time to file affidavit in reply is extended by 2 weeks. List the matter before the next available circuit under the heading hearing after the time fixed herein above for filing affidavit in reply. Next,
Number 53, WPS 300 of 124 with WPS petitioner, my lord.
not today. But Miss Nag was there in the first term. Where she has gone? Where on Friday, 7th February.
Item number 55. Lord, I am for the petitioner. I received the affidavit in opposition. I want to file reply.
Reply.
A week's time may be given. File பண்ணிட்டீங்களா?
Client advocate representing the petitioner prays for time to file affidavit in reply. Stop. Time to file affidavit in reply is extended by. No. Prays time to file affidavit in reply. Stop. Time to file affidavit in reply. Petitioner shall be at liberty to file affidavit in reply by 2 weeks. By 2 weeks.
My lord, next circuit will be taken up. Next circuit.
Yes, yes, by 2 weeks. Stop. List the matter before the next available circuit after the time fixed herein above for filing affidavit in reply. After 2 weeks, next circuit will start.
17th it will start.
Yes, the next hub it will, in the next week it will appear.
Right. Right.
I have agenda matter for 2 weeks so that you can file your reply. Yes,
Item number 56, WPS 331 of 124.
I pay for the respondent
The
authority.
senior is appearing for the petitioner. I pray for not to take it.
My
next
parents-
Monday, 10th February.
My parents.
Today I have not passed any order.
Item number 57, WPS 342 of 124.
Lordship, in this matter, my senior appears on behalf of the petitioner.
Come on,
No, Your Honor. Learned Advocate N.A. Khan, Nadeem.
N.A. Khan.
I am praying for not today.
Next Monday,
Obliged.
you have difficulty on Monday. So then it will be on today's 5th, 6th, 7th February.
Obliged.
Item number 58, WPS 16 of 124 with item number 59. I will seek for extension of time.
Reply. First extension, Mr. Jaipal. Then as a last chance. Already as a last chance, I have said by 30th January 2025. So that matter can be taken up.
But which can retain in the list, I'll argue, because there are several grounds have raised for attack the impugn order. One of such ground is the audio autumn pattern has not been complied with. Adverse materials were collected against me, were used.
No, if you don't want to file an affidavit in reply, then I can hear you.
Not take the chance, because it may happen so during course of hearing.
Then this court will not hesitate to decide the matter. But I need to record this.
May I get one more chance to file?
Though video order dated 27 January 2025. As a last chance, time to file affidavit in reply was extended. But Mr. Jaipal, learned advocate representing the petitioner, has paid for extension, which would enable him to file affidavit in reply. Next paragraph. Respondents are represented by learned advocate. Next paragraph. Time to file affidavit in opposition stands extended by 1 week. A time to file affidavit in reply stands extended by 1 week. Extension of time to file affidavit in reply is peremptory. Next paragraph. List the matter before the next available circuit under the same heading.
WPF 425 of
60 my lord, on the ground of Mr. Kabir's personal difficulty, I'm praying for next circuit. My lord.
There was no direction for affidavit.
Everything is.
Where is Mr. Kabir?
That matter, Mr. Kabir.
Which was mentioned. Yes, what has happened to Mr. Kabir?
No, now he's stuck in a VC. He said, upon instruction, I am submitting, my lord. Next circuit is.
So let it be on 7th February. Let me see.
Blair.
Number 61.
Or at least some of the matters will be in the list. Let it be on 10th February.
10 times are difficult.
You have said so. 7th February.
Number 61.
7th February. Yes, 61.
Madam, I'm for the official respondents.
Who is for the petitioner?
Nag. This is Nag.
11th February. Ms. Nag is for the petitioner. 11th February. Huh? 10th February. 10th February. 10th February. Yes.
Number 62. WPF 475 of 2024.
I'm for I pay for that one number private respondent. Up 2 and 3.
Respondent numbers 2 and 3.
Compliance.
Who is for the petitioner?
Compliance with the order.
Some appeals was pending.
Eight November 2024, the respondent had to supply the copy of opposition. They have given me. I'll seek time for filing.
As per submission, grant counsel of the petition. Land advocate representing the petitioner prays for extension of time, prays for accommodation to file affidavit in reply. Next paragraph. Petitioner shall be at liberty to file affidavit in reply by 2 weeks. Stop. Respondents are represented by learned advocate. Next paragraph. List the matter before the next available circuit after the time fixed herein above for filing affidavit in reply. When it is expiring?
Month of January. Because they have used January.
Already expired.
Expired by lot application.
Leave is granted to the learned advocate to file an application for re-imposition of interim order. Next.
Number 63. WPF 525 of 2024.
Yes,
Retain the position in the list. It's a matter related to electricity connection.
not today. On 7th. 7th.
Item number 64. WPF 546 of 2024.
Madam, I'm for the respondents. I've already filed my affidavit of opposition.
Who is for the petitioner?
Vijay Kumar. Not today.
7th February.
Item number 65.
Or let it be on 10th February. Why you all are playing for time on 10? You will be there on 10.
Last day. Let it be.
10th will be the last date. Some matters should be there on the last date. Yes.
Item number 65, W.
Trailer for the extension, my lord.
I pay for the petitioner.
Are you opposing?
Not much.
But there is a previous extension, Mr. Chakraborty.
7 days.
As a last chance, time to file affidavit in opposition is extended by 2 weeks. Stop. Petitioner is represented by learned advocate today. Next paragraph. List the matter under the same heading before the next available circuit. After the time fixed herein above for filing affidavit in opposition. Stop.
Much obliged.
Yes.
640 of 2024.
I'm appearing for respondent, my lord.
Yes. Mr. Jaipal. Yes. We'll come back tomorrow, let me see. Not to.
Instead of tomorrow, can it be day after?
7th.
Day after.
Adjourn till 7th.
Oblige, my lord.